here's, when we briefed this and you've read it, let me just summarize what our position is. There's a well-established rule of statutory construction that courts can use the expression, should use the expression of one thing in a statute to imply the exclusion of another. Now, how does that principle of law relate to this case? Well, 2-21-121, parens 4, which is the statute the Republicans think has been violated here, is included in as a subparagraph of 2-2-121, which has 4 paragraphs, obviously. The second and the third paragraph also contain sort of ethical prohibition. Subsection 2 prohibits the public officer from using state time, facilities, equipment, supplies, personnel, and the state funds for his own private business. 2-2-121, parens 3, the third paragraph of that section, prohibits the use of time, facilities, equipment, supplies, personnel, and state funds for campaign purposes, to oppose somebody or to promote somebody for election. Frankly, in that regard, subsection 3 and subsection 4 appear to do the same thing. I mean, they appear to me to be redundant. But the significant thing is that there's 2 significant things about the way those statutes appear in the code. The first thing is that the section upon which the Republicans base their complaint does not prohibit the use of state funds, does not prohibit the use of time, facilities, equipment, supplies, and personnel. And as a matter of statutory construction, because that section does prohibit the use of those in the preceding 2 paragraphs, but not in the 4th paragraph, that it must be read to exclude those time, facilities, equipment, supplies, and personnel. And the thinking, I guess the principle behind this general rule of statutory construction is that the legislature presumably knew that when it wanted to prohibit the use of time, facilities, equipment, supplies, and personnel, it would say that. And because it didn't say that in subsection 4, it doesn't prohibit the use of those services. Secondly, the subsection 2 and 3 subsection 3 that prohibits the use of time, facilities, equipment, supplies, personnel, and state funds in connection with a campaign has an exception in it. And that exception is that the section doesn't apply if the public official is engaging in things that are part of his or her ordinary public duties. That exception doesn't appear in subsection 4, which reinforces our argument that while the legislature may have wanted to prohibit a state official from paying for ads on the air, it did not stop him from using personnel, time, facilities, equipment, supplies in connection with the production of those ads. If you construe it that way, again, it will have a significant impact on the governor's ability to carry out his duties. Now, let me talk a little bit about the issue of the clarity of the statute, because I think that's a significant point. As I understand the Republicans' argument, this statute is clear, and so we should just apply it as it is. We think that it is unclear both in terms of its meaning as well as how it should be applied. And that's significant because it carries a penalty, a civil penalty. And there is a generally well-accepted rule of law that when there is a civil penalty or a criminal penalty associated with some proscription, the proscription has to be clear and unambiguous. And a court will always construe it very, very narrowly in order to avoid due process problems. And that principle is an important principle for you to consider when you're looking at the statute, because put yourself in Brian Schweitzer's shoes. Someone calls him and says, someone from the media calls and says, I told the secretary I need to have a comment from the governor about this public issue. The governor's busy at the time, and the only way that he can do this, he does this fairly regularly, is to record a statement that can then be emailed or sent to the media so that they can have his comment on the air. He's got to stop and think, can I do that under the statute? Because this statute prohibits me from using state time, I'm on the clock, using state equipment, my little MP3 player, and sending it to a newspaper or a television station for a broadcast. And as I understand the Republicans' position, there is a blackout after the governor files, and he can't do any of that kind of thing. I think that is an absolute absurd result, but it is one that is created by the statute and the uncertainty in that statute, and I think that it's up to you to very, very narrowly construe that statute in order to make it clear to this governor, to the Secretary of State, to any other public official, what they're doing or not doing in order to keep on the right side of the law. We don't have any problem with the idea that we're prohibited from going out and buying airtime to run some ad. We don't have any problem with that. But we don't think that this prohibition applies to the governor when he's in his office, his facilities, his personnel, his supplies. I mean, Sarah Elliott is going to be paid for her 40 hours or 100 hours or however many hours she works a week, whether she does something for KXLO or not. That MP3 player is just sitting there. Nobody's going to use that. If the fact that somebody picks it up and uses it is not something that is going to cost the taxpayers of Montana 1 red cent. And that sort of gets me to the legislative history. I was hoping, frankly, that I would find something in the legislative history that made this real clear. And I've looked through it and I've listened to the tapes. I don't think either counsel for the Republicans or myself is going to be able to point out anything in the legislative debate that's going to help very much on either side of this question. But you have to keep in mind that this law, Senator Torpedo introduced this law by his own words to deal with Mark O'Keefe and Bob Brown's huge expenditures of monies while they were auditor and Secretary of State. In those cases, I think it was Mark O'Keefe had some settlement monies that had been received for fines, and I think it was like an amount to $133,000 that he was using to pay for the production of an airtime to put his name and face before the public. Bob Brown got federal money in connection with the revised election laws after the Bush-Gore issue I think it was like $130,000, and he did the same thing.